documentation on the residential property has indeed been disclosed. And you'll see in Exhibit A, Your Worship, that there is the bond document from the ABSA Bank detailing with the said property. And just to correct the record, it hasn't been sold. It was on auction through ABSA Bank, but the sale never went through, so it still remains the same. And Mr. Agrizzi and his wife, his common law wife, are still living there. Just to correct the record in that regard, I think my learned friend in the address or in the submission or in the affidavit suggested that it had been sold. It was supposed to be last week and didn't get sold.
Right, I'll hear your closing arguments in that regard. Let's contain ourselves to the content of the affidavit.
I refer to paragraph 8.12 of my affidavit on the 6th of February 2019, where I stated I have funds available for bail for which my wife will arrange should this become necessary. I wish to set out briefly the position relating to my motor vehicles and assets which were dealt with in or about the end of 2018. I was represented by a different legal representative who were in contact with the present investigating officer in regard to me providing full assistance to the state in any prosecutions that would ensue. It was only at the middle of January 2019 that I changed my legal representatives and that I'd been called to the State Capture Commission in order to give evidence and to provide my cooperation and assistance. Immediately after I'd given evidence on or about the 18th of January 2019 to the State Capture Commission, various persons connected with Bosasa African Global Operations tried to have me arrested on criminal charges. On February the 5th, 2019, my legal representatives were at a meeting with the Hawks in Germiston, Brigadier Lawele and his team, where my full cooperation and assistance was being discussed with various cases that they were investigating arising out of evidence that I'd given at the State Capture Commission. On the same day, towards the late afternoon, the investigating officer, Colonel Lazarus, contacted my legal representatives to inform him that he'd received instructions to arrest both myself and other accused to appear in Pretoria Commercial Crime Court. Arrangements were then made to attend at their offices in Pretoria, where we were handed over and formally charged and appeared in court, where I was then released on bail of 20,000 rand. When dealing with my bail affidavit, as it was a Schedule 5 offence, I instructed my legal representatives to deal with my South African properties and assets being furnished and other assets. I did not in any way deal with property which was purchased as an investment for my family as a bed and breakfast, as that was only purchased in March of 2019. I have attended and assisted the South African Revenue Services at inquiries that were held, and these assets being the property was disclosed to them, as well as the amount of funds that I transferred and given to my common law wife. The property where I presently reside was not sold on auction, which the bank were requesting, and I'm still residing together with my common law wife at the said property. There was sufficient media coverage given on various news channels and publications relating to the public auction which is being held at the insistence of ABSA being the bondholders. I confirm that the property was in fact purchased in Italy as an investment, and the amount in respect of the legal fees and transfer duty was paid, and all this was done with Reserve Bank approval, including all the transferred. I would request the above honourable Court to take this asset and approximate values into account. In respect of the cryptocurrency investment, I state as follows. Owing to the current economic times, as well as the fact that I required income, I received financial advice to invest in cryptocurrency. I am willing and able to assist the investigating officer with all the records that he needs in regards to my cryptocurrency purchases and sales, and I have from the outset tendered him my full cooperation and assistance. I state further that I did not deal with mine or my wife's offshore assets in my applications. I was only dealing with assets in the Republic of South Africa. I have still given my full cooperation to all the entities of the state, and I have no intention in relation to not disclosing these assets, as in all respects they are full public records, and before any transaction was done, the authorities were approached to get the necessary approval in terms of the regulations. I deny that I have in any way misled the Honourable Court in Pretoria or any other court in relation to mine and my common law wife's assets. I am further willing and able to assist the investigating officer with any queries that has in regard to any further financial aspects relating to the matter. I have also been involved in negotiations with the financial institutions in order to try and reach a practical settlement in regard to my financial commitments. I would further respectfully request the above honourable Court to take into account my current precarious medical conditions, together with my comorbidities, as well as the unfortunate increase of COVID-19, especially in the Department of Corrective Services. This was dated and signed and affidavit at Palm Ridge the 14th of October 2020. And if the court is in agreement and satisfied, as well as my learned friends who I've given a copy, I'd ask that this be accepted as part of the record and be marked Exhibit D, Your Worship. And then just to emphasize, Your Worship, in Exhibit A, we attached a medical report from the specialist physician pulmonologist from the Life Fourways Hospital who's been attending to Mr. Agrizzi, and he set out in the letter and he clarified my learned friend and myself, Advocate Nyoni, were in contact telephonically, and I have the signed one that we brought to court on the 1st of October because she required the medical certificate in all fairness, and we cooperated as we've always done, and we brought it and we just asked her to sign to confirm that she had received the original medical certificate. And in the copy he set out exactly the position that he expected Mr. Agrizzi to be able to appear in public on the 14th of October 2020. When in public, he'll require continuous use of oxygen either via an oxygen cylinder or portable oxygen concentrator, and he then sets out the diagnosis as well as the problem relating to the stress and his well-being, and it was signed by the specialist physician pulmonologist. So I'm not sure if Your Worship wants the one that was signed by my learned friend, or whether it will suffice the one that we handed in that has been signed by the specialist physician pulmonologist, just in order to assure the court that we've given them our full assistance and cooperation. And if you're satisfied, then as I've submitted, it could be marked as Exhibit D, and that would then be the case at this stage for the applicant in regards to him being released on bail.
Thank you. The document that you have lastly referred to, Dr. Cohen's letter, is a signed copy which is attached to your Exhibit A.
Yeah, Chauhan. It's Dr. Mohammed Chauhan, specialist physician.
I apologize for the incorrect pronunciation.
Yeah. No, sorry, it's just correct. I've got the copy. Thank you.
Thank you, Mr. Agritzi. The second replying affidavit, you confirm that you understand the content thereof?
That is correct.
And do you confirm that each and every fact contained therein is indeed true and accurate?
That is correct.
Thank you. Court received this second replying affidavit as Exhibit D to the record.
As the court pleases.
Right, Mr. Witt, if you are then ready with your closing argument.
Yes, thank you. I am, Your Worship.
Thank you. May proceed.
Yes, and it seems hopefully we might have reached some consensus, so I'll be to the point as Your Worship has correctly pointed out. Your Worship, in considering whether or not, especially in terms of Schedule 5 of the Criminal Procedure Act 51 of 1977 and the position relating to bail, you correct it is whether or not it is in the discretion of the court in the interest of justice to release the applicant on bail. In order to assist the court, we have set out and provided the court with the original affidavit, which was Annexure A or Exhibit A, together with B and D, in order to deal with the current situation. Now, firstly, Your Worship, what we'd respectfully request the court to take into account that throughout the, one can call it at least the past century up until the present time, the court has always looked at the question of bail, and in regards to the exercise of discretion, that it is in the interest of justice, and more particularly that they will always look at the freedom of the individual, and more particularly with the advent of the Constitution, our interim Constitution in 1994, and thereafter the Constitution Act 108 of 1996, and in particular Section 35, which deals with the various rights of suspects of people that appear as accused in court, their rights, etc., and obviously there are limitations, and that it would indeed be the situation that you would look at the right of freedom of movement, the right of privacy, and you would look at all the respective rights and, in essence, the freedom of the individual. and then as opposed to that you look at the various other aspects. Now what we have set out for the court is, from the outset, and I'm not talking just about this particular matter, and it is in the affidavit, it's not in any way disputed by the state, Mr. Agrizzi, at great danger, not only to his own personal safety but that of his family, decided, after he had approached Colonel Lazarus long before this case had even been laid or even been investigated, with his previous legal representatives, in order to try and offer his assistance to the state. And I don't think there's any dispute on that. So he went on his own, together with his previous legal representatives as well, in order to try and assist the state with investigations and information. I was not the legal representative, neither was my instructing attorney, Daniel Witz of Witz Incorporated. We only came into the matter in January, towards 3 days before state capture, into the matter. We were unaware that he had then been placed in protective custody for his safety and that of his family, and he was being kept in protective custody because of the revelations that he was going to make, which I think at the end of the day has woken up the Republic of South Africa and probably a lot of people all over the world as to certain allegations and evidence as to what was going on in the Republic of South Africa. Immediately after he gave his evidence on the 18th of January, when I was present, there were attempts by Bosasa and or African Global Operations, as it then became named, and certain of their directors and people, to have him arrested on a minor charge, but in other words to have him arrested so he couldn't give any more testimony before the State Capture Commission. Fortunately, with the intervention of the legal representatives, some of the investigators of the State Capture, that was all put one side and was dealt with accordingly. What then happened is, on the 5th of February, instructions were received that Brigadier Lawele of the Hawks, which is the same unit as Colonel Lazarus, except he's at the Pretoria unit and Brigadier Lawele runs the Germiston unit, they were investigating various dockets against various persons that had been mentioned by Mr. Agrizzi in state capture, and they required his assistance as well as the assistance of people who worked with him. While we were at that meeting and while everything was confirmed, at a later stage that afternoon, Colonel Lazarus then made contact and said he's now received instructions, and we thought there'd been a crossing of hairs or crossing of swords between the different units of the South African police. We were cooperating with the one section of the Hawks, the head, Brigadier Lawele, and then Pretoria phone and say, we've received instructions, we have to arrest your clients. So accordingly, we then went to court, or first to the officers to be charged, formally charged, fingerprinted, have all the formalities dealt with, handed ourselves over, and then bail was then agreed, where my learned friend, one of my learned friends, was present, and the matter was then adjourned. Now, in that particular application, an affidavit, which forms part of Colonel Lazarus's affidavit, was furnished, dealing with his personal aspects, dealing with all the aspects. There was no problem of him being a flight risk. There were no problems at all. And that situation continued all the way through 2019. Mr. Agrizzi then went to the Special Investigation Unit he was summoned to, the South African Revenue Services inquiries, full cooperation, documentation, assistance, whatever was needed, he cooperated with the state. Then there was never any indication of any opposition to bail or any problems with the bail. What then happened is, Your Worship, that unfortunately the whole world, and of course unfortunately this country as well, the pandemic COVID-19 then struck, and on the 25th of March 2019 the Honourable President then gave the emergency regulations and the lockdown level 5, and obviously it affected the courts and the functioning of the courts. But up and until that date, which is the 25th of March, Mr. Agrizzi had absolutely no problems. He was assisting, cooperating with the state, cooperating with Colonel Lazarus. There had never been any problem or any suggestions of anything that was incorrect. What then happened thereafter, Your Worship, and I think this is an important fact in regards to this bail application, is that arising out of that, there's been various postponements. Advocate Rousseau, who is assisting Advocate Nyoni in this particular matter, then came into the matter in Pretoria at the Specialised Commercial Crime Court. And I think this is important that the court knows when you talk about cooperation, the way the matter should be done before it arrives before your worship between the state and the defence. Everything that needed to be done was done in writing. The state would always correspond with my instructing attorney saying, what can we expect on the next occasion, what is needed, is there going to be disclosure, what is still outstanding. Everything has been done. Are there going to be representations? Whatever has been done, we've communicated with the state and kept it the way colleagues should behave and the way colleagues should conduct. In other words, as your worship I know is very, very quite strict on, you prefer some type of pre-trial procedure. So when a matter proceeds to trial before your worship, you now can narrow the issues. You can see whether there are admissions, what you need to deal with, what exhibits, etc. All this was done all along, never been any problems. Then came the pandemic, and through the pandemic, when we arranged the remands, etc., we also ensured each and every time that Mr. Agrizzi and the other co-accused, but in particular the applicant, was at court timelessly, and the remands were then done. And as I say, the last one in July of this year was remanded till Friday, the 16th of October, where he has to appear again. I then received a call from my learned friend explaining that after an investigation had been done, and this was prior to, I think it was December 2019 or early January, we were requested by Captain Nevin, who's assisting Colonel Lazarus and his team, to please attend at the VGM building in order to ensure that a warning statement is given by Mr. Agrizzi, and the arrangements were then made that he would then deal with the prosecutors, and if and when and if they decided they wanted to prosecute him as an accused and not use him in any other aspect as a Section 204 witness or as a normal witness, whatever they decided, the arrangement was they would contact us and we would then arrange to bring him to court or bring him to their offices, whatever was needed. And all along, since February 2019, it's always been the arrangement, and we've always done that. What then happened is, my learned friend then phoned me to say to me that a decision had been made that they intended arresting Mr. Smith, that it would be by arrangement with his legal representatives. He would appear in court, and can we appear in court on the 1st of October. Unfortunately, Mr. Agrizzi, owing to health conditions, had been hospitalized just prior to that and was then placed at home and on oxygen, and you have the proof thereof, and we then arranged with my learned friend. And the date that was arranged was the 14th of October, that is today's date, for a formal bail application. All our discussions, before I even address the court any further on the law and on the position, all our discussions were done on that basis, and all we were really debating about, which obviously is in the discretion of your court firstly, whether you grant bail, was the amount of bail. And my learned friend's attitude was that she wanted a higher amount of bail, and we were debating that, and that's where it landed up till this morning. Now, if you look at the affidavits, you're dealing with a South African citizen, you're dealing with someone who has been in South Africa, born in South Africa, has his family here, has his children here, has his common law wife here. They've been together for 28 years, has built up various assets, made various investments, and up and until the time that he could not deal with it anymore and could not take it anymore, and his life was becoming a living nightmare, and more particularly on Christmas Day, December 2016, when he had the terrible incident relating to his health condition, which to a large extent he said came from various pressures and what was happening at work and what was going on, and he couldn't deal with it anymore, and he was revived twice on the operating table, and then things took a turn and took a change, and eventually he decided that he couldn't deal with what was going on at Bosasa or African Global Operations, and eventually he resigned and he received his exit and retrenchment package. He then decided, and he approached, and I think this is common cause, my learned friends are aware of this, he approached firstly the head of the asset forfeiture unit at the time, Mr. Willie Hofmeyer, and said, listen, while I've been working there, I've picked up all this information, I've seen what's going on, please can you help me, can you direct me? He received no help there. He went to see Colonel Lazarus together with his legal representatives, long before charges were laid, long before any arrests were made. He also went to speak to Glynis Breitenbach, who at that stage was head of the Commercial Crime Pretoria and then became the Shadow Minister of the Democratic Alliance in Parliament, dealing with justice. He tried everything in order to bring this out in the open, and eventually, when the state capture, which we heard was now going to come into operation, we were not the legal representatives. At great risk to himself, he then went along and started working for many, many weeks and months, handing over documentation, everything that's arising out of this case that will eventually come before this court or another forum in order to assist the state. So that is the type of person that you're dealing with that is now applying for bail. I heard with my learned friend, her respectful submission, that things changed when they saw the affidavit because certain things, according to them, were not disclosed. We submit very, very simply, Your Worship. The assets are there, they've been disclosed, everything's been done with Reserve Bank approval. If there was any omission, he's admitted it now in his Exhibit D. He deals with the asset and the values of the assets. And we submit that at the end of the day, when you look at the legal position and you look at the interests of justice, that he has indeed made out a case where you're dealing with a South African citizen with no previous convictions. There is a pending case which he disclosed immediately, the case that he's appearing on in Pretoria Specialised Commercial Crime Court. There are no other cases against him of any criminal nature. And what is also important is that, unfortunately, and this is something that the court does have to bear in mind, you have to deal at this stage with the health condition. My learned friends correctly submitted, they're not disputing his medical condition, etc. And if Your Worship takes judicial cognizance of what is going on, unfortunately, not just in the Republic of South Africa, we're over 18,000 already that they know of officially on the figures that have deceased since COVID-19. And unfortunately, there's been a rapid increase in the crowded circumstances of the corrective services. Now, normally, if bail is refused, people are normally taken from this court. They'd either be taken to Modder B prison in Springs, or to the Boksburg prison, or to Johannesburg Central Prison, known as Sun City, which is the nickname given by the prisons when they first opened it, because it was a new building and modern, and they said it looked like Sun City in Rustenburg. So it picked up that nickname. That's one of the places you go. Awaiting trial, as you already know, you've heard evidence before you can take judicial cognizance, is overcrowded, unfortunately. There are various problems there. And in relation to the position, it's even common knowledge that, unfortunately, the head of the Johannesburg prison and one of his assistants both passed away recently in the last 6 weeks of COVID-19. So there's a rapid increase and there's a rapid problem relating. And if you are of a certain age with certain comorbidities and certain weight issues, etc., your chances of getting the COVID-19 are actually increased. So these are factors that the court will take into account. We would also respectfully request the court to take into account, when looking at the various principles, and the fundamental principle, which is to uphold the interests of justice. And in this particular case, there's no suggestion at all that is a danger to the public. There's no suggestion at all from the state side that it would undermine the public confidence in the functioning of the judicial system and the bail system. There's nothing at all, Your Worship, in regards to not leaning in favour of the liberty of the subject, provided, of course, that the interests of justice will not be prejudiced thereby. There's also the aspect, as the accused has shown, not only in his trials and not only in his appearances at court. There's never been one day where he hasn't appeared at court or hasn't appeared at an inquiry, as and whenever he's required or requested by either the state capture, by the Special Investigation Unit, all the inquiries that he's been attending, he's the first one there to attend, and there's never been any absences or any problems at any stage. So when you weigh up all the various aspects, Your Worship, in regards to whether or not he should be released on bail, our respectful submission is that we have indeed made out a case for the applicant to be released on bail. If Your Worship, after hearing the state, considers it, we will then discuss with the court briefly. They did prepare, correctly so, and when they gave me what they call their pack, a draft order in relation to certain other aspects, depending upon what Your Worship decides. I believe the draft order was handed up to Your Worship, which you're not bound by. You can obviously amend or deal with it depending on the various aspects that they've set out. And our respectful submission would be that when you take all the various aspects into account, that the applicant has indeed discharged the onus on a balance of probabilities in regards to this matter, whether or not it's in the interest of justice to release him on bail. And if one takes all his prior conduct, if one takes everything into account with his cooperation and assistance, with the fact that he's here, his family are here, everything that he's got basically, other than the investment, which, as I say, was already disclosed and it's now been put and set out in Exhibit D, that he has indeed satisfied the court that he should be released on bail, together with any conditions that the court might consider. And if one considers that aspect, I'm not going to address the court because you still have to hear my learned friend and deal with it. I would say, and we've already submitted it in our own affidavits, there's no question of passports or travel documents or going anywhere near airports. That is obviously a no-go ground for the accused in this particular matter. Not that you can go anywhere or not that you can do anything, but we would obviously comply with any conditions that the court might decide after hearing all the various aspects. And that would be our submission to the court. Thank you, sir.
I have no doubt, and I can gather from the direction which the affidavit of the investigating officer placed emphasis on, is that the state is trying to build a substantial submission that your client has set up quite a livable lifestyle beyond the borders of South Africa, which could provide him an escape route. Do you want to say anything? How should the court consider that?
Yes, that is what the state have tried to set up. I would say that there's not a matter of setting up a lifestyle. It is simply a matter of trying to find an investment, especially after he gave evidence. You'll see all this was done, if you look at the dates, all this was done just prior to him going to state capture and going to give evidence. He obviously realized there were going to be certain problems relating to his coexistence and existing here. So he decided to do an investment for himself and his family, not to leave the country. He hasn't been there since he was arrested. He hasn't attempted in any way to go there, and in fact he received permission with Colonel Lazarus. He said, I've got no problem at all with your client. I've got the passport. You want the passport, you can have the passport. Take the passport, you can travel. It all depends. And only when the state capture requested him to cancel, because we gave them the travel plans, we sent it through to Advocate Sarunia, said this is his trip, he's going to Italy, it's partly business, partly leisure, etc. There seemed to be no problem at all. So it wasn't a situation of trying to build and set up a nest egg to leave the Republic of South Africa. Yes, it is correct what your worship has set out. There are assets there. The assets are now set out in Exhibit D. No problem at all with that. And as I say, these assets have been disclosed to the South African Revenue Services. These assets were obtained with Reserve Bank approval and permission. It's not a matter of building up a nest egg and you did it surreptitiously, or you did it without permission, or you did it without. If it was that situation, your worship, I can assure you I wouldn't be standing here and making these respectful submissions. So it's not a matter of building up a nest egg and going to live somewhere else comfortably. Everything was done properly, everything was done legally, and everything was done in terms of regulations and permission. There's nothing at all suggested by the state that anything has been done in any untoward manner. So my submission on that would be that there's no suggestion at all that he was trying to set up and leave. It was a form of an investment, and I mean, many people, you can approach, I think anybody who's around who's got either unit trusts or investments or pension funds are only too grateful if your pension fund or your investments are investing offshore, because it seems, unfortunately, for the way South Africa is economically at the moment, most of your growth seems to be offshore. And I'm not a financial expert, as opposed to what is happening locally. So there's never anything untoward. The Reserve Bank have welcomed it, they've encouraged it, they've asked people that are residents to, if you want to invest offshore, they've increased the allowance. I think it's now something up to 10 or million plus. So there's absolutely nothing untoward there, as long as you get permission and as long as you get the proper regulations and permission from the Reserve Bank. So everybody's investing offshore. Not necessary to leave or to go live another lifestyle, either in regards to investments or whatever the position is. So that would be my submission in that regard, Your Worship. So there's nothing untoward or nothing sinister, as the state seemed to be trying to make out from Colonel Lazarus. There's nothing sinister at all. And it has now been set out.
Thank you, Mr. Woods.
Thank you, sir.
Thank you.
Thank you, Bishop. It's our submission that this court must find that in the interest of justice for the applicant to be released on bail, and if the court comes to a finding that it is in the interest of justice for the applicant to be released on bail, this court would need sufficient information to rely on to decide which bail conditions would be sufficient to ensure that the applicant don't abscond and that he attends court and stands his trial. Now, for this court to come to a decision in that regard, the court relies on affidavits filed by the applicant and the respondent. The problem, Your Worship, is not that the applicant has assets in Italy or offshore assets. That's not the problem. The problem is that he failed to disclose that assets to this court when applying for bail. Worship, he painted a picture of a person who's got 2 million in loose assets or movable assets in South Africa. And 14 million in fixed assets or immovable property. What he failed to disclose, Your Worship, is that he has 30 million rand in foreign assets, half of which is a fixed property, and we know that there's a luxury vehicle involved as well. Now, by failing to disclose this, he puts the court in a position that the court would, the court would have to take this foreign money into account when, if it's say, for instance, the court decides, yes, it's in the interest of justice of giving this person bail. This court would have to decide what would be a proper amount of bail. Now, a person with 15 million in fixed assets in South Africa would be treated differently from a person who's got 30 million overseas. So it's our submission, Your Worship, that the problem Mr. Agrizzi has, the applicant has, is not that he has foreign assets. Many accused has foreign assets. The problem is that he failed to take this court into his confidence. Based on the previous bail application, he prepared an affidavit setting out the foreign assets of the applicant. This morning, when we were given his affidavit, and we noticed that again, he failed to disclose his foreign assets to this court. We were duty bound to oppose this application and put the record straight with regards to the foreign assets of the applicant, as well as the fact that he's been prioritizing foreign assets over retaining his fixed assets or his trust's fixed assets in South Africa. Your Worship, that is the gist of this matter. I am not going to deal with any averments made outside of affidavits filed in this court. May I refer the court to the last affidavit filed, the responding affidavit, Annexure D, that in this case again, the applicant failed to disclose the full extent of his foreign assets and the nature thereof. He just by passing mentions the fact that he invested in a B&B, bed and breakfast. Doesn't disclose vehicles. He still doesn't disclose cash. So even when he filed Exhibit D, he's still not taking this court into his confidence. Your Worship, there are many other factors that my learned colleague put on record. We cannot deny the fact that we are dealing with an epidemic. We cannot deny the fact that the applicant in this matter has comorbidities and there's a high risk of him suffering serious consequences if he were to contract this disease. We cannot deny that. But, as I said before, he had a duty to disclose to this court all factors that might be relevant for this court to properly apply its mind and to decide, number one, whether or not he should be released on bail, and secondly, if so, on what conditions. Your Worship, I cannot take it any further. If a court would, in principle, decide to grant bail to the accused or the applicant, then we will address the court on possible measures to ensure that he do stand his trial. But at this stage, it's our submission that his failure to take his court into his confidence was fatal and that he should not be released on bail. May I please?
Mr. Rousseau, just before you sit down, your main concern is the fact that Mr. Agritzi possibly is a flight risk due to the financial interests which lie beyond the borders of South Africa.
That's correct, Your Worship.
And you say that, in essence, you harbor that fear because he did not disclose those interests, and that should be interpreted as having set that up to escape, if possible, or provide himself with an escape route or escape plan. Is that how I am to understand you?
Indeed, Your Worship. Worship, if you look at the dates on which the money was sent out, you heard from my learned colleague that at the time he was already in discussions with the prosecution. The Bosasa matter that he stands accused on in the Commercial Crime Court in Pretoria comes from 2006. It was clear that he knew that his game was up, and he set up, and he sent out this money, as my learned colleague informed this court, while he was in talks with the prosecution. And then the talk stopped, and he went to the State Capture Commission, and as I say, in the meantime he started sending out money and acquiring foreign assets. So that, coupled with the fact that he did not disclose it, is indicative of the fact that he intends to abscond at some stage or another. If he were to disclose it, that would have been a different matter. I probably would not have much of an argument, but he did not disclose it. He hid it from this court.
So the next consideration is it possible to somehow block that escape route? For instance, because it's the flight risk that is of concern to the respondent, preventing him from leaving the country, perhaps through red flagging departure for his name at customs, and or with Home Affairs in obtaining new travel documents. Will that suffice into addressing your concerns, or do you not think that is possible?
The only problem we have is that the South African borders to our neighbours are basically open. Yes, it would be possible to prevent the accused from leaving South Africa through a normal international port. We can block his South African passport. We can red flag him internationally via Interpol. That all can be done. But the one thing we can't do is to prevent him from moving over to one of our neighboring countries and traveling to any country if he has, for instance, an Italian passport. That we cannot stop.
Now, the reporting of the lost Italian passport to the Italian embassy, would that prevent them from issuing a new passport to him?
I cannot see that would prevent him from issuing a new passport, Your Worship.
Is it within your reach to notify them not to authorize or issue a new Italian passport to Mr. Agritzi?
Your Worship, we can obviously attempt to do that, and as I said, we did take the liberty of drafting a draft order for this court, setting out strict measures, much stricter than we did for Mr. Smith, for instance. We've got reporting conditions.
Just let me finish with my questioning. One of his escape plans is vested in his financial interests offshore,
Yes.
as you have emphasized. Is that touchable? Is it within your ability to freeze those assets, in a sense that Mr. Agritzi cannot touch it or use that money? Is it possible?
Your Worship, I really don't know. I can explore that. Yeah, we can explore that. I haven't looked into that.
I was informed through Mr. Woods and the content of the affidavits that the local bank or banks have already frozen his bank accounts. Can you confirm that? Do you know that? Is that
Your Worship,
within your knowledge?
I know that his ABSA account was terminated. I don't know why it was done. I know that no further payments was made into that account. What is present situation with regard to the banks, or I don't know. But we are not aware of any assets being frozen or any funds being frozen by any of the South African banks. And if we look at the type of transactions that followed his arrest, we see money being transferred to DC Agrizzi's account and her account being used. So it doesn't seem as if there's a problem with regards to DC Agrizzi's account. So if that answers the question, I'll report.
Right. Now, our next crucial point, which you have not given me much to work with in your affidavit or in your submissions, is what is the strength? Where lies the strength of the state case against Mr. Agritzi? That is surely one of the starting points that the court must consider.
Your Worship, we filed a draft indictment, which is on record. In that draft indictment, we actually quote verbatim an instruction of Mr. Agrizzi to a lawyer to pay from his trust account money he's holding in trust for Bosasa to a business account of Mr. Smith. And not only that, but to make a payment reference on this transfer, accident claim settlement. Yeah. So the strength of the state's case is good. We would not come to court with a prominent politician and a high net individual like Mr. Agrizzi if we did not have a good case.
And your allegations, are they all substantiated through affidavits that have already been obtained?
Indeed, yes.
And how advanced is your investigation?
Worship, save for some affidavits to be obtained from Parliament, and that is more formal affidavits, the investigation has been concluded.
Do you have an estimated time limit to or time frame to the conclusion of your investigation?
Worship, we should be, the next date is the 3rd of December, we should be able to disclose the full case docket by the 3rd of December. And that would include, as I say, 1 or 2 affidavits that's from Parliament. That's still outstanding.
Thank you, Mr. Rousseau.
Thank you, Worship.
Thank you. Just briefly,
Mr.
Worship,
Woods,
with your permission. If you look at paragraph 17 of Exhibit D, the accused does confirm that the property was purchased in Italy as an investment and the amount in respect of the legal fees and transfer duties was paid, and all this was done with Reserve Bank approval, including the transfers. And he then discloses the offshore assets in paragraph 20, that this was all done with permission. But the interesting point that you raised, and I think it's a crucial point, Your Worship, if that is the strength of the state's case, I don't want to debate the state's case now. What they're omitting to tell you is something very similar. You won't be dealing with the trial, and you can deal with it in the bail application. All those instructions came from the late Mr. Gavin Watson. He was the one that interacted with Mr. Smith. This was a messenger at best. So to say that he's the one who created and he's the one that's involved, if that's the strength of your case, and I'm afraid to say, Your Worship, I think whoever trials this matter might have certain difficulties, maybe even Section 174 or maybe even a nollie prosecute, because that's no strength at all. If that is what the state are relying on, that was the instruction that was given, they haven't been candid again and told Your Worship, but hold on, the affidavits that we've got and the proof that we've got is that all this was arranged by the late Mr. Gavin Watson, not by Mr. Agrizzi. He was just the instrument that was used to make the payment, but it's not his money. It was Bosasa money or the late Mr. Gavin Watson's money. Not a cent came from Mr. Agrizzi, not a cent changed hands from Mr. Agrizzi to Mr. Smith. Everything came from Bosasa and or Mr. Gavin Watson and others. So if that is what the strength of the case is, it makes it even more an aspect that the court would consider releasing him on bail together with suitable conditions, if that is what the state are relying on. So I'm very glad we didn't actually deal with it either in the affidavits, because we don't know what the case is. We were just told, please can you come to court, please get processed, we're not going to oppose bail, we'll sort it out, and then we can then disclose and we can then talk at a later stage, which I discussed with my learned friend telephonically. I said, once he's released, once bail's fixed, we'll come and talk and see what it is. But if that is what the case is, then I'm afraid to say, Your Worship, with the utmost of respect, if that is what they're relying on, then they haven't been very open and candid to this court. Never mind talking about assets. You, as an officer of the court, you've got a duty as a prosecutor. There's certain prosecutorial guidelines and duties. You should say to the court, look, that is what we've got. We've got a documentation and instruction to say, please pay this into Euroblitz, which later turned out to be a company that Mr. Smith is the director of. But what they don't tell you is that's who the money belonged to. That was the instruction. That's where the money came. And what happened thereafter, as you will see at the state capture, and we'll see in the evidence if this matter ever gets off the ground and in trial, as a result of that, certain things happened that had nothing to do with Mr. Agrizzi. It was direct contact between the late Mr. Watson and Mr. Smith. So if that is what the strength of the case is, then that's even more reason, Your Worship, with respect, to release him on bail. In fact, I'd even go so far, Your Worship, to say if that is the strength of the case, I'd even release him on warning, on his own recognizances. You don't even need bail if that is what the state are relying on. But leaving that aside, I submit that an amount of bail in a reasonable amount that is affordable together with conditions should be imposed, and that would be our submission to the court. Thank you, Your Worship. Sorry, one last aspect, Your Worship, with your permission, and that information was what Mr. Agrizzi told the state capture and told the whole of South Africa. That is where they got it from. They would never even known that this even existed. All that came from his openly and voluntarily, at his own the safety of himself and his family. He told them about this, and he said, have a look who organised. It's not my money. I never gave Mr. Vincent Smith 1 cent of my own money. I never loaned him money. I never did anything with him. This was all arranged by the late Mr. Gavin Watson and Bosasa. And what they then did and what then happened, you need to establish and find out. And that's what state capture are busy doing. So if he didn't come along and disclose that, it would have been put in file 99. No one would have even known that this had happened and existed and the roles that were played. So it all came from him. So unfortunately, I think what a lot of people are going to learn from this, that is the peril of being a whistleblower. You whistleblow at your own peril, either your own safety or that of your family, or alternatively, the state look at it and say, okay, well, now that we know what happened, well, let's charge him because the person that perpetrated the offence, if an offence was committed, he's no longer alive. So let's get the messenger, let's get the person who paid my money over to somebody else, not his money. He got no benefit, he got no gratification, so where's the corruption? So if that's the strength of the state case, with the utmost of respect, Your Worship, I would seriously think in regards to the question of bail. That would be my final submission. Thank you.
Thank you, Mr. Agritzi. I saw that you were taking strain in remaining standing, so I will permit you to sit down while the court gives judgment. You're welcome to be seated. Judgment extempore. Mr. Angelo Agrizzi appears before this court on an application for the granting of bail. The application falls within the ambit of Schedule 5, which requires of him to adduce evidence to satisfy that the interest of justice will permit his release on bail. The state at this stage, in this particular case, is preferring a charge of corruption, which they inform the court of some of the details at the onset of this matter, involving a corrupt transaction of approximately 800,000 rand. They also allege that the corruption took place in participating with others in a common purpose. Now, this application is opposed by the respondent. The court has listened to several affidavits. I will refer to them during the course of my judgment. I've also listened to the closing submissions by Mr. Witts representing the applicant and by Mr. Rousseau representing the respondent. With reference to the affidavits before me, it is necessary that I just try to summarize the more important facts. It is not my intention to repeat all the evidence. It is on record. It is fresh in my memory. I will only highlight in a summary fashion the important issues. The initial founding affidavit, Exhibit A by Mr. Agritzi, in support of his application, details that he is a 53-year-old. Well, if I look at his date of birth, I think he'll only turn 53 in December this year, so he's still 52 years and approximately about 9 months, 10 months. He is married. He's got 2 children, both of major age. There are also two grandchildren. He's a South African citizen. His passport, his South African passport, is with the investigating officer. That was handed over during a previous bail application at the Commercial Crimes Court in our neighbouring town in Pretoria. And this passport, I am informed, has by now already expired. He informs that there are no previous convictions. However, he has this pending case at the Pretoria Commercial Crimes Court for which he was released on bail in the amount of 20,000 rand. Then there is also an Italian passport. This, however, went missing, lost at his home, and even after a vigorous search, he was unable to locate or find this passport. And there is a letter to confirm that he reported the lost passport to the Italian embassy. He resides at number 97 Helder Fontaine Estate. This is a bonded house. It is valued at approximately 13.5 million rand, but there is an outstanding bond of about 8.1 million rand. He is currently employed by an entity called CEMEC Hampton Property and Property Match, and he earns an income of approximately 55,000 rand per month. He does have money available towards bail in a reasonable amount. He has movable assets to the value of approximately 2.65 million, together with his now ex-wife. He has immovable property to the value of approximately 14 million rand. All his relatives reside within the borders of South Africa. He also then intimates that he has cooperated with the investigating officer as well as the National Prosecuting Authority from the onset. He has also assisted in providing and parting with his knowledge by giving evidence at the state capture inquiry, which is referred to as the Zondo Commission. He was recently hospitalized. He is currently under medical care. He has entered my court carrying a mobile oxygen unit with him, and he informs that this is currently his medical position. He has to carry the oxygen unit with him. He intends pleading not guilty to the allegations against him. He denies the allegations, and he intends making representations to the National Prosecuting Authority. Then he details that he will not jeopardize the criminal justice system or bail system as envisaged in the provisions of Section 60, subsection 4, paragraphs A to E of the Criminal Procedure Act 51 of 1977. Mr. Wits also immediately submitted a replying affidavit, which the court received as Exhibit B. This after receiving and reading the intended affidavit which the respondent wanted to submit. This replying affidavit, in a summary fashion, informs the court that Mr. Agritzi in 2016 had a near-death experience. Based on this, he then decided to make arrangements with his finances, and this led to him transferring of money to his ex-wife in order to protect some of his finances. Now, the affidavit, and I will not go through the details, it is quite substantial, then explain how money was transferred, when and where to, and the amounts that were mentioned. He denies that he ever provided the investigating officer, the NPA, or the Commercial Crimes Court in Pretoria with any misleading or false information. As the reasons for taking the steps of transferring the money, he says that his local accounts were all frozen by the local banks. He also undertakes not to apply for any new travel documents. He reiterates his valuable contribution to the State Capture Commission. Attached to the affidavit is a letter confirming his reporting of the lost Italian passport to the Italian embassy. That, at that stage, closed his application. The respondent then replied, and they made it clear that they are opposing the release of Mr. Agrizzi. After reading his affidavit this morning, the prosecution says this brought them to the decision to oppose the release of Mr. Agrizzi on bail. Mr. Rousseau, representing the prosecuting authority, then presented the court with an affidavit by Lieutenant Colonel Lazarus, who is the person seized with the investigation of the Pretoria Central CAS 1556 of February 2010, received by the court as Exhibit C. Colonel Lazarus informs the court that during the bail application in Pretoria, they did not consider the applicant to be a flight risk. And they agreed to his release on bail. During that application, he referred to many aspects which are basically copy and paste in the current affidavit today, which is referred to as Exhibit A, pertaining to his residence, movable and immovable property, and the undertaking that he will not abscond. However, since February 2019, which was when that application was conducted, further and new evidence came to their attention, which brought them to a different view pertaining to bail. The information that they obtained was of such a nature that they considered bringing an application in terms of Section 68 of the Criminal Procedure Act 51 of 1977 to have the bail of Mr. Agrizzi revoked, but because it was the time when the lockdown was announced, they did not deem it apposite at that stage to pursue that, because Mr. Agrizzi in any event in their view had nowhere to go. No movement was allowed, or very limited at least. So they left that until a later opportunity. In the current matter, Colonel Lazarus is of the view that he has sufficient grounds to support that Mr. Agrizzi poses a severe flight risk to the respondent. Neither Mr. Agrizzi or his wife hold any mentionable assets in their own name locally. All, or at least most of it, is currently in the Agritzi Family Trust. Due to the provisions governing trusts, these assets are generally untouchable or unattachable by any creditors of the accused. The information also indicated that motor vehicles were transferred to the ex-wife's name. The vehicle mentioned, the Ferrari, was thereafter sold. A BMW 760 motor vehicle was bought from that sale and then again thereafter retransferred back to Mr. Agrizzi's name. Substantial transfers were made between 11 December 2018 to 19 January 2019. Now, the importance of that date is this is the month just prior the state capture inquiry where Mr. Agritzi then testified in. That date, if I'm correct, was mentioned as the 18th of January when he testified. Large sums of money was transferred to an offshore investment account between 21 December 2018 until 3 January 2019, mentioned just short of 12 million rand. Colonel Lazarus tries to explain where the funds came from or sourced from and where they went. I will not go into details. It is, as I've said, on record. At the date of the formal bail application in the Commercial Crimes Court, Pretoria, the joint combined balance of Mr. Agrizzi and his wife, several bank accounts, was substantial. Offshore amounts of more than 24 million is mentioned. However, he did not disclose that in Pretoria at the bail hearing. Colonel Lazarus further indicates that, in his view, the fixed property locally is not of severe concern to Mr. Agritzi, because he focused the transfer of most of the money offshore. The salary that he mentions that he is currently earning cannot even service the interest on the outstanding bond amount on the property that he did mention. The investigating officer is further aware of a process that Absa Bank has initiated or in the process of initiating in order to recover the outstanding money on this bond. There is also substantial amount of money in a Luno cryptocurrency account, and he detailed how much was spent investing in Bitcoin and Ethereum, how much was made and how much was transferred in and out of those accounts. But in his view, the offshore investments were prioritized by Mr. Agritzi and not in his local assets. He has also established that a bank account was opened in Italy 12 November 2018. There is an account in the name of the wife which was opened on the 30th of March 2020. In this account there is more than 700,000 euros. When the prosecutor in July, now that is after the bail hearing in Pretoria, asked Colonel Lazarus whether the Italian passport was handed in to him. He was not even aware of the existence of this passport then. So in conclusion, Colonel Lazarus is of the view that Mr. Agritzi poses a severe flight risk to the respondent, based on the fact that he has the means to sustain himself should he leave South Africa, as well as the fact that he withheld and misled information to the Commercial Crimes Court Pretoria should there be an extradition application. It will be costly as well as time consuming in order to have Mr. Agrizzi return to South Africa to stand trial. Colonel Lazarus ended off by saying that in his view the interest of justice will not permit the release of Mr. Agrizzi on bail. That was the close of the opposal by the respondent. Mr. Witts then, after considering his options, submitted a additional replying affidavit. I refer to it as the second replying affidavit, received as Exhibit D to the record. In this, he aims to address some of the concerns that were not addressed by the Exhibit A and the first replying affidavit, Exhibit B. Mr. Agritzi in this affidavit explains the transfer of the money to the offshore accounts. He also tries to explain why this was never disclosed to the court at the Pretoria bail hearing. He denies that there was ever an intention from his side to mislead the court. He reiterates again his willingness to cooperate with the investigating officer. He adds in this replying affidavit that the court should consider his medical condition and his comorbidities in view of the COVID-19 pandemic, which is still in South Africa, and especially within the confines of the prison system. That was again the close of Mr. Agrizzi's application then for the second time. The court then listened to the closing arguments by Mr. Witts and by Mr. Rousseau, and as you've heard, Mr. Agrizzi, I posed several questions to both of them in order for me to absorb as much information as I possibly can in order to be informed before deciding on judgment. In considering an application of this nature, the court must always remind itself of the principles pertaining to a bail application. The matter of S versus Stanfield, 1997, Volume 1, SACR on page 221, in bracket C, held and reiterated the principle that a person's liberty is of utmost importance, and that bail is not penal in nature. A person's liberty should not be withheld without good justification. The matter of S versus Matebula, 2010, Volume 1, SACR on page 55, in brackets ACA, it's a Supreme Court of Appeal decision. Acknowledge the fact that the applicant has to satisfy the burden on his shoulders in such an application on a balance of probabilities. Contrary to public belief, when any accused person is arrested, they must not be given bail. That is what generally the public believe. Until you find yourself stranded on the wrong end of that belief. Now, the reason why that is a wrong belief is there is a presumption of innocence in our law, enshrined in Section 35 of our Constitution. You are innocent until proven guilty. Indeed, our Supreme Court of Appeal has acknowledged that there are certain categories of offences which require a burden of proof on an applicant to satisfy before the applicant can or may be released on bail. Two of those instances we find in the listed offences in Schedule 5 and Schedule 6. We are currently dealing, as I have earlier indicated, with a Schedule 5 ambit bail application. Section 6011B of Act 51 of 1977 provides that in a Schedule 5 but not a Schedule 6 application, the court shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that the interest of justice permits his or her release. There can be no doubt, Mr. Agritzi, the wording of that provision place a burden of proof on the applicant. As was said earlier, and important to consider, that proof is something lesser than the usual proof or burden of proof on the state in a criminal trial. In the bail, this is on a balance of probabilities. This was also confirmed not only by the Matebula decision I mentioned supra, but also by the case of S versus Scott Crosley, 2007, Volume 2, SACR on page 470 in brackets Supreme Court of Appeal, SCA decision. Bail is a means to secure and accuse attendance at a court hearing. It is not an instrument to punish him in anticipation of a conviction. The important consideration, which I have to keep reminding myself, is: does the interest of justice permit Mr. Agrizzi's release on bail? Now, the interest of justice, if one thinks of that, for purposes of what we are dealing with, is that Mr. Agrizzi stands trial until it is finalized. Now, as a starting point, the strength of the state case is of vital consideration. If the case for the state is relatively weak in merit, the court will then rather lean predominantly in favor of the granting of bail. If, on the other hand, it is clearly a strong case in existence, it will balance out that consideration, and the court will then look at other considerations. Now, I need to emphasize that the bail court is not in the same favorable position as the trial court, who hears evidence presented before it, challenged in cross-examination, tested for strength and weaknesses, in order to then make a evaluation decision on the merits. To a large extent, in a bail hearing, the presiding officer has to rely on affidavits such as we have seen. Affidavits who cannot be cross-examined. Affidavits of the version of the one party and the version of the other party. If the scales are mutually balanced, the court will look at other alternatives, such as, are there less evasive means to address the interest of justice, rather than depriving the applicant of his liberty? In other words, will strong-worded bail conditions address all the risk factors? On the strength of the state case, you heard the court question Mr. Rousseau, and thereafter Mr. Witts took an opportunity to counter-argue on the strength of the state case. In a bail hearing, the court, as indicated, largely depend on submissions by the prosecutor as well as the investigating officer, usually contained in the affidavits, in order to satisfy itself whether there is a case in existence against the applicant and whether it is strong or whether it is a weak merits. Mr. Rousseau, on his address in this regard, assures the court that there is a strong case in existence. He informs the court that their case is based on certain instructions which were given, and he quotes verbatim what the instruction was, which they allege was given by Mr. Agritzi. Now, this is a matter which has attracted a huge public interest and media interest. The National Prosecuting Authority will really be red-faced if they take a matter to court of public interest like this matter has, and this blows up in their face. I heard counter-arguments by Mr. Wits. Mr. Wits indicates that, in his view, if that is all the state have, he thinks that there is going to be an abrupt end in the trial. It will not run its course. That is if the matter even starts at all. Now, I cannot predict the future. And it is almost expected of me, in this regard, to predict the future. I can only work on the facts before me. I am at least satisfied at this stage that there is a case in existence against Mr. Agrizzi. I cannot take that any further. What I am satisfied with, that from what Mr. Rousseau informed me is in existence, there is nothing against Mr. Agrizzi. There is a case in existence, a prima facie case in existence against Mr. Agrizzi. A further consideration is how long the state is still going to be working on finalizing their investigation. Because this can have an influence also on whether it is justifiable to curtail the applicant's liberty. Now, I'm informed that they expect they will be ready to make full disclosure by December 2020, which is approximately 2 months or so from now. So if the court denies bail, it means that the duration of Mr. Agrizzi in custody before the matter goes on trial has been reduced. Clearly, there is not a lengthy duration of investigation that still needs to be conducted. The next consideration is the version of Mr. Agrizzi in his combined affidavit, founding affidavit and replying affidavits. To say, in a nutshell, the facts contained therein are ordinary in nature. He has a fixed address. He is employed. He has assets. He's got family attachments and roots in South Africa. He's got reasonable quantum of bail available. He will not jeopardize the criminal justice system or bail system in general. And he commits himself to stand trial. The respondent's fear lies primarily in the fact that they say Mr. Agritzi poses a risk of flight. They did not oppose bail in the commercial crimes Pretoria bail application. But subsequently, fresh facts to their information have brought them to new insights. Mr. Agrizzi, in the Pretoria matter, failed to disclose substantial financial interests, liquid funds beyond the South African jurisdiction, including a house that was purchased in Italy as well as a luxury motor vehicle. Several offshore bank accounts. In them, there's more money than most South African middle class can earn in a lifetime, probably combined. Definitely enough to sustain a more than average lifestyle if he absconds abroad. Now, it was criticized by Mr. Wits that the state could have, if they were so concerned, brought an application in the Commercial Crimes Court Pretoria in terms of Section 68 of the Criminal Procedure Act to apply for the revoking of Mr. Agrizzi's bail, which they failed or omitted to do. Now, the reasons for this presented by the respondent is that due to the COVID lockdown and travel movement restrictions, there was no urgency in following this route. Currently, the travel restrictions have been substantially eased. Although not fully open, they have been substantially eased, which means that some travel is now allowed even through the known border posts. The respondent, in my view, have definitely made out a substantially convincing case that the abandonment of local assets will not present any major financial impact on Mr. Agrizzi if he loses it all. The respondents have also managed to paint a colorful picture of a well-planned and structured movement of money from South Africa to virtually untouchable accounts, or at least not without major effort. And of course, in the hope that the authorities cooperate in the foreign countries to assist them The picture painted, in my view, speaks of a preparation by Mr. Agritzi to set up a life beyond the borders of South Africa. This structured movement of money took place between 2018 until even recently in 2020. A large portion of the transferred transactions was in the immediate 3 to 4 weeks preceding his evidence giving in the state capture inquiry. It is public knowledge by now that Mr. Agrizzi, this was also referred to by Mr. Witts in his submissions, is seen as and considered the whistleblower to the Bosasa involvement into state capture. So that the heat would be turned on against Mr. Agrizzi, I don't think is news to him. He had time to consider his options and plan of action, what he would do once his whistleblowing commenced. Now, his actions, by blowing the whistle, I want to emphasize in the strongest fashion. It's applaudable. There should be more people that have the guts, like Mr. Agritzi, to come to the fore and speak up of wrongdoings. No doubt he cooperated with the investigating officer by presenting himself for processing, providing medical confirmation of his condition, since his co-accused appeared before this court approximately 2 weeks ago, and the reasons why he could not avail himself then to be processed. But on the flip side of the coin, which stands out, is the fact that on 2 occasions, and on the affidavit, his initial founding affidavit, Exhibit A, the paperwork speaks for itself. Then the affidavit pertaining to the bail application in the Pretoria Commercial Crimes Court was attached also for the court to view. He, for some reason, decided to withhold disclosure of his foreign investments and assets. It was only until it appears he felt compelled today, after seeing and or hearing the opposal affidavit by the respondent, that he felt and deemed it apposite to prepare replying affidavit in explaining his assets beyond South African borders, and tried or attempted at least to satisfy explanation why he did not disclose this at the hearing in Pretoria. And not only that, in his founding affidavit this morning, when he had the first opportunity to present these facts to this court. Now, there is an Italian passport which is missing. Yes, there is documented reporting of this passport that went missing to the Italian embassy. The question is leaving the country now safe? Or, putting the question in a different manner, is there no risk to the state that he may abscond because he does not have a passport in hand? Yes, indeed. And I pose the questions to Mr. Rousseau, because these are some of the considerations that I needed to obtain in order to fully familiarize myself with all the facts so I can make an informed decision in a very limited period of time. The Department of Home Affairs, as well as the Customs, no doubt can be notified so that they red flag Mr. Agrizzi's name should he attempt to exit the country through any of the border posts controlled by them, or so that no new travel documents would be issued to him through the Department of Home Affairs. I extended that question to Mr. Rousseau pertaining to the Italian embassy. He was a bit uncertain about whether that is possible or not possible. But whether it is or is not, I cannot blind myself. I can't put blinkers on my eyes. And I will be naive to do so if I deny that our borders are porous. If you want to make such a statement, you will be the laughing stock, no doubt. Even without a border, without a passport, however, with money in hand, you can ensure safe crossing into one of our neighboring countries. From there, anywhere else. Now, from all considered, I'm satisfied that Mr. Agrizzi has the financial means to set up and sustain a comfortable lifestyle elsewhere. From what is before me, it appears it may be Italy, should he decide to abscond. Can these fears and risks be addressed in a less evasive manner? Now, if Mr. Agritzi wants to abscond, no bail condition is going to keep him here. Even if his name is red flagged to Customs That will assume that he then tries to depart from one of the controlled border posts. Mr. Rousseau has addressed the difference between a person in South Africa with approximately 15-16 million rand assets and the same person with 30 or more than 30 million rand in an offshore investment. What amount of bail for a person with these financial means will keep him here? Should we wait? I spoke about the predicting the future a few minutes ago. Should we wait to see if he absconds and then act? The court can only act on what is before me now. These risks is not based on a thumbsuck. It's based on a convincing opposal by the applicant, by the respondent made out against the applicant's application. Indeed, as Mr. Wits hailed, there's nothing wrong with foreign investments, and all the investments were done and all the assets were acquired abroad legally through knowledge with the revenue services. That is indeed so, and that is not challenged by the respondent. The issue is, then why hide it? Why not disclose it from the onset and say, yes, this is what I've got? On two occasions, Commercial Crimes Court Pretoria and this morning, initial founding affidavit, nothing is said about this. Now, Mr. Wits, in the last replying affidavit, Exhibit D, as well as in his closing arguments, mentioned Mr. Agrizzi's health condition. Indeed, it is of concern. And the court saw when he walked into my court today on more than one occasion, as I've indicated, he carries with him a mobile oxygen unit which is attached to him. It's common cause that he has health concerns and comorbidities. And indeed, that puts him at an increased risk, especially if in confined enclosure such as in the correctional services system. However, his health concerns is not the only factor which has to direct which way the bail hearing goes. I refer to a case of S versus Van Wyk, 2005, Volume 1, SACR, on page 41. It's a Supreme Court of Appeal decision, in brackets SCA. I quote, "The function of the court in a bail application is to prima facie determine the relative strength of the state's case and not to make a provisional finding of guilt or innocence. Insofar as an accused does not receive proper medical attention whilst in detention, she or he has other legal remedies at her or his disposal, and in general, bail is not the remedy of the actions and omissions of the prison authorities. What remains important is the fact that the restriction of her or his detention and the attendance at the trial is not ideal for a person in a weak physical condition. Naturally, the interference with her or his freedom is an important factor which has to be given much weight when deciding on the interest of justice. But the medical condition of the accused must be weighed against the other factors and must not be considered in isolation. Close quote. The interest of justice, that catchphrase which I keep on reminding myself, and I referred to it earlier also, needs to see that Mr. Agritzi is held accountable at a trial. The interest of justice require answers into as well as recovery of incomprehensible amounts of money which were misappropriated. The biggest headache of the National Prosecuting Authority I'll refer to it as the Gupta saga, and their accountability is extradition to South Africa to stand trial in order to account for the allegations against them. I cannot contribute to yet another name being added to that headache. Mr. Agritzi, after all considered, your application for bail is dismissed.
We have arranged a date which is the 3rd of December, the same date as Mr. Smith, for the remand, and we'll deal with this matter further. And just one aspect I just want to place on record so that there's no misunderstanding or misconception. There was nothing meant at all in relation to the reference to the late Mr. Gavin Watson, and in fact, if anything, sympathy should go to him and his families for what unfortunately occurred in that tragedy. So just in case anybody takes it up the wrong way, I just want to place it on record. Nothing was at all meant in that regard.
Thank you, Mr.
So
Woods.
I'd like to just place it on record. Thank you, sir.
It is a court, Your Worship. I confirm that the date of 3 December was indeed arranged, and that the case of Mr. Smith's been remanded to that date.
You mentioned that was for disclosure. That was earlier today by your colleague next to you.
Indeed, Your Worship, that's for disclosure.
All right, you tuned into SA Today here on SABC News. Of course, what you were just watching there is that long, really, bail application of former Bosasa COO Angelo Agrizzi. And of course, the breaking news then this hour, which we will be dissecting throughout SA Today this afternoon, of course, is the application for that bail dismissed by Magistrate Philip Venter, who went into quite a lot of detail about why he was weighing all the odds there, kind of looked at all scenarios and came to that decision. And interestingly, at the end of it, saying after what we all kind of saw with the Guptas and the headache that the justice system has had trying to bring them back into South Africa to answer for the monies appropriated. He said he cannot, the magistrate said, I cannot contribute to another name being added to that headache. Having said this, application for bail dismissed. So that is the breaking news then at this hour here on SABC News. Do stay with us, more after this.